So I've told you the basic scenario. Let's start with this question. What's the first question to ask in a departing employee case? So a client comes in or calls you, and there's a departing employee situation and a dispute. Let's say it's the employee who you're representing. And he said, I just got a demand letter from my former employer. What do I do? What's the first question you think you ought to ask that client? Any suggestions?
Put in the contract.
What's in the contract? Yeah.
Do you have it?
Yeah, do you have a contract? That's a good one. I mean, that's usually, that used to be my question number one. It used to be, well, let me see your employment agreement. It doesn't have a non-compete. What else does it have in it? That used to be my question number one. But that's fallen to question number two. Any other ideas? What's the first question? What's another key question you want to ask? Well, for me, the question I've started asking right at the beginning is, what documents did the employee take from the employer? Right? Now, notice, I didn't say, did you take any documents from the employer? Or do you have any documents from the employer? I don't know that I've ever had a case where the employee literally had 0 documents that came from the employer. Maybe one or two. Some really smart employees may do that to protect themselves, but most of the time, the employee has some company documents, right? And sometimes it may be for a perfectly legitimate reason. It might just be, yeah, I used to work at home sometimes, and I would key myself work documents at home, or I would put them on USB drive. So sure, I have some company documents on my Gmail or on my home computer, things like that. Could be totally legitimate. On the other hand, you often get situations where you have employees behaving badly, and you see things like the day before leaving the company, the employee emails herself a bunch of company documents to her personal Gmail account. By the way, that's not really that sneaky. Pretty easy to figure out when somebody has done that. Or somebody, they get onto the company, they log in and they download thousands of files from the company's database just a week before announcing their resignation. You see scenarios like this a lot, where people are just not that smart about what they do before leaving. So that's the first thing I really want to know, because that issue is really going to color all of the rest of the issues in the case, whether it's the non-compete or trade secrets or fiduciary duty. That's because it's going to give a flavor to the case. And I'm going to, if I represent the employee, I know I'm going to have a more uphill battle if the employee took some confidential documents on the way out the door. Okay, and then the issue that arises with this is preservation of evidence. That's my issue number one. Now, preservation of evidence is an issue now in every litigation, of course, and you've all heard about preservation of electronically stored information, or ESI. That's a key issue in any kind of litigation. But it's especially important in departing employee litigation. Why is that? Any thoughts on that issue? Why is it especially important in these kind of cases? Well, for one thing, in these cases, often the issue on the merits may have to do with when and how the employee took documents from the company, right? Now, there are some cases where, when the documents were emailed or how or who, it really isn't that big a deal. It's really just a matter of what did the email say. But in a departing employee case, the metadata associated with the documents can be critical. Because, for example, it may show the employee mailing trade secret material to a competitor before leaving the company, something like that. So it's especially important in these cases. And of course, as you know, there is a common law duty to preserve evidence, including electronically stored evidence, when there is a reasonable anticipation of litigation. If you're in a departing employee situation where there's friction or there's a demand letter, you can pretty much say people are reasonably anticipating litigation. So issue one is preservation. Now, what will happen to you, let's say you represent the second employee, okay? And you want to know, all right, we need to find out if the employee we just hired, if he took any documents on the way out from the other company. So you'll ask the employee, and typically their initial reaction is going to be, no, I don't have any confidential documents, I don't have anything like that. But you need to press the employee for details, okay? And it may not be that the employee's trying to hide something, but sometimes people just don't think things through. You really have to press for details. For example, let's say it's a question of whether the employee has a customer list, all right? Well, the employee probably doesn't consider the contacts on his smartphone to be a customer list, but it could be, right? Names and contact information for key customers, that could arguably be a trade secret. And I'll get to that in a little more detail later. But that's the kind of thing where the employee doesn't necessarily think that she did anything wrong, but she might have something that the first employer considers a trade secret. And that leads to something I call Wolfe's first law of trade secrets. It's very scientific. And the law is, whatever company documents the employee took will become the trade secrets in the first employer's lawsuit. Right? I mean, this is kind of just a common sense thing. Now, that's not 100% always the case. An employee can take trade secrets just in the employee's mind. You know, if I work for Kentucky Fried Chicken and I find out, you know, the secret formula, I could theoretically take that in my mind to the second employer. But as a practical matter, the way it usually works out is that whatever the company finds out the employee took, they will argue that that's the trade secret information, right? The company doesn't sit there and say, okay, let's think of, what are our trade secrets? Okay, it's X, Y, and Z. All right, let's go see if employee took X, Y, and Z. No, it doesn't work like that. They work backwards. They look at, what did the employee take? What can we prove the employee take? And then we're going to argue that is the trade secret material. So that's, again, why this issue of preservation of evidence is so important. Okay, so my practice tip, I've already mentioned, which is press the client for details about documents taken from the employer. The case I'm going to recommend to you on ESI in the context of departing employee cases is this case, In Re Methodist Primary Care Group. This is a very recent case out of the Houston Board of Appeals. And what you had in the Methodist primary care case was two physicians who left one practice, went to a competing practice, and then of course there was a lawsuit. And as far as I can tell, it wasn't a non-compete situation. It was a lawsuit where the first employer was claiming claiming trade secrets, okay, trade secret misappropriation. And the employer served a request for production asking for information on revenues that these two physicians generated from referrals for what they call ancillary services at the new medical practice. So basically they want to show revenues, damages flowing from the alleged misappropriation of the trade secrets. And this illustrates the importance, I think, of pressing the client for details, because the second employer responded to those discovery requests for documents showing revenues from referrals for ancillary services by saying none. So the response was none. Now that's fine, but then in a deposition of a representative of the second company, it came out that the company had the ability to generate from its electronic practice management software a list. They could do a breakdown of various physicians and revenues generated by referrals by those physicians. And so the trial court judge here in Houston looked at that and said, I don't think I believe you when you say none. And so I'm going to order
that you have to let the plaintiff's forensic expert have direct access to your cloud-based database so their expert can look for this information. Okay, this is direct access to devices. Now, some of you may remember there is a Texas Supreme Court case on this direct access issue. It's called Weekly Homes. And Weekly Homes kind of lays out the procedure for what you have to do to get an order for direct access. Because that's kind of an unusual thing, right? We don't typically let the other party come in and look through our file cabinets. And in the same way, we don't typically let it's not an ordinary procedure to have the opposing party or their expert just take my laptop, for example, and run searches on it. So the trial court judge ordered that, went up on an appeal, and the Houston Court of Appeals essentially said, the trial court judge went a little too far under Weekly Homes. And the main problem was that the trial court judge did not first consider whether less intrusive means would suffice. So if you're trying to get this direct access, you need to remember, but first you gotta find some intermediate step of some less intrusive means to get what you want.